In tonight's edition, at last we have some more state allocation numbers. Doha names and shames businesses that exploit foreign workers, increased processing times for the 491 visa applicants, and 11 hot tips on how to prepare yourself when asking for a business visa sponsorship. Hi, I'm Karl Konrad and welcome to our weekly edition of Australian Immigration News. This program is proudly brought to you by Australian Immigration Law Services, the company I founded in Sydney now more than 26 years ago. On Friday morning, Tasmania was the first state to release the numbers allocated by the Department of Home Affairs for this financial year. They have been allocated 1,200 places for the 190 visa and 650 places for the 491 visa. You can see by our comparison table here that these numbers are a significant drop compared to last year's quota of 1,400 and 1,300. These new figures will be a significant blow to those living in Tasmania who are hoping for 491 sponsorship. As I'm filming this video on Friday lunchtime, the numbers for other regions have not been released. But if they are after filming, you can see they've been added here in this comparison table. We were expecting a drop in the allocated numbers, and I'm afraid this is exactly what we've got. Just when you thought it couldn't get any scarier to open up the Department of Home Affairs webpage, the processing time for the 491 visa has hit an astonishing 27 months. This week the department updated the processing times, and as you can see on the screen here, there has been very little improvement elsewhere. The numbers continue to climb, crushing the hopes of many applicants. If you missed our video last week about explaining of processing times, we'll leave a link in the description for you. And in breaking news, we have a Facebook release from the Department of Immigration that says the next invitation round for the 189 visa will be next week on the 13th of November. So stay tuned. For the very first time, the Department of Home Affairs is publicly publishing a list of employers accused of exploiting international workers. Minister Julian Hill, who incidentally is not the actual immigration minister, was tasked to issue a press release about this new policy. The press release says that they will now publicly name and shame employers who breach the Migration Amendment Strengthening Employer Compliance Act of 2024, which came into effect July last year. And who is the first offender? Well, it's a Western Australian business called AILS Deli, which promotes itself as offering wholesome foods. They have been issued the very first employer prohibition notice under this new act. According to the minister, the company has been banned from employing foreign workers for the next 5 years. The minister is quoted as saying, "The government new laws are in force, and this public notice is a clear warning to any employer tempted to mistreat their workers. Don't do it. Migrant workers are an essential part of our economy. There is no place in Australia for employers who exploit them, and now everyone will know who they are." As for AILS Deli, well, now they're stuck with sourcing local Australians, perhaps to stand in the scorching Western Australian heat in sweltering caravans, serving hot dishes. Good luck with that. Before you have that conversation about visa sponsorship with your employer, be sure you are armed with as much information as you can gather. Also, knowing your employer's perspective is crucial in sponsorship negotiations with them. Some employers have done it all before and know what's involved, while others have never done it at all and have no idea. This video is not just for visa applicants, but also for those potential employers looking to find out what's involved. Businesses incur significant costs when sponsoring employees under both the 482 and the 186 visa categories. The Skill Australia Fund and business application charges cannot be passed directly on to the employee. I'll leave a link in the description for both the 186 and 482 overall visa costs. For the 482 visa, the business must also pay a proportion of a legal advisor's fees, with the employee only allowed to cover their own share. Of course, if the business wants to, they can pay for all of it. Conversely, for the 186 visa, the employee is permitted to pay the full cost of professional agents' fees. For larger businesses, these costs often have a minimal impact on the decision to sponsor. However, for micro, medium and small companies, the cost can be a significant factor. Government organisations that sponsor visas also need to consider their budget allocations. These costs can also influence when a sponsor may be prepared to support you for the 186 PR stage if you're already on a 482 visa. For example, if a company sponsors an employee for a 482 visa and then a year later the employee qualifies for a 186 direct entry stream, the employer may hesitate to sponsor again so soon given the costs involved. Many companies employ numerous workers on temporary visas who have not been sponsored, such as those on working holiday and graduate skilled visas. Management often fears that sponsoring one employee could trigger a demand from others. This also applies to businesses who already have a high number of 482 visa sponsored staff. They may want to continue having a temporary resident 482 visa workforce rather than sponsoring them all for PR via the 186 visa. Other companies reserve PR sponsorship for upper management only. Knowing a company's policies beforehand may save you from disappointment. There are often practical limits on how many staff a company can sponsor. The Department of Home Affairs generally prefers to see a smaller ratio of sponsors staff compared to Australians or permanent residents. While there's no specific legal percentage, sponsors with more than around 30% of sponsored staff may face a higher likelihood of rejection. An exemption to this would be if the employer has a labour agreement in place. How long has the employee been with your business? A committed, hardworking employee may be a strong candidate for sponsorship simply because they deserve the recognition and reward. Such employees are viewed as assets to the business over the long term, which can outweigh the costs of an application. In high-demand occupations such as doctors, nurses and teachers, offering a quick pathway to permanent residency, often via the 186 direct entry stream, can be a critical incentive to attract and retain talent. State and territory governments also tend to reserve their 190 visa invitations for occupations with significant shortages. Many employers have invested considerable time and money in training staff for specific roles. Repeating that investment for new hires can be far more costly than sponsoring someone who's already fulfilling that role. Often the decision comes down to just numbers. Many employers appreciate the fact that sponsoring someone under the 482 visa can help them retain employees for more extended periods. Employers often prefer employees to hold the 482 visa for at least 2 years before offering sponsorship for permanent residency. The long processing times for the 186 visa should be taken into account though. Is it fair to expect an employee to work for a company for 2 years and then they have to wait for another 2 years or longer for processing? These are issues both the sponsoring business and the employee should be aware of. In small to medium businesses, the relationship with your employer and their view of your value can be crucial. A supportive boss who sees you as an asset might regard visa sponsorship as a worthwhile investment, perhaps even a tax-deductible way to secure your loyalty. In larger organizations, however, HR or senior management may be less personally invested, and your supervisor's advocacy becomes crucial. If you're really fortunate, you might have an employer who genuinely likes having you around and is willing to go that extra mile to support you. Unfortunately, such employers are rare, but they do exist. We find most employers are willing to disclose their financial statements, BAS returns, and organizational details to support sponsorship applications. Others may be hesitant or even anxious about such transparency. While it's difficult to predict how an employer will respond, being aware of this aspect is essential. In reality, if an employer takes time to read the full scope of the sponsorship obligations a business is responsible for, many would just give up. From the employee's perspective, avoid this topic like the plague. If the employer brings it up and they are still prepared to discuss sponsorship with you, this is a very good sign. Now, of course, this list we have compiled is not comprehensive. We would like to hear from our viewers what has been your experience in gaining or trying to gain employer sponsorship. Please leave your comments and I will endeavour to go through them in another video. Well, that's all we have time for tonight. Stay tuned for next week's edition and the updates that will occur in the world of Australian immigration. Remember, if you need help, we are always here to lend a hand. You can book a consultation online, but if you're in a hurry, just pick up the phone. As always, take care out there and I'll see you next time. So bye for now.